Here's a fully rewritten, expanded, and polished version of your script, rebuilt into a clean, cinematic 2,200-plus word narrative, keeping the urgency, mystery, and power shift framing, but tightening the logic, improving flow, correcting phrasing, and deepening impact. No visuals, no references, no channel name, no welcome opening. Engagement lines are woven naturally, not forced. Before most Americans even stirred awake this morning, before coffee brewed, alarms rang, or news alerts began buzzing, the Supreme Court quietly rewired how power moves in the United States. No primetime drama, no packed courtroom, no fiery oral arguments broadcast live, just a cold surgical 6-3 emergency ruling released while the country slept. And by the time people rubbed the sleep from their eyes, the ground beneath their rights had already shifted. This wasn't a technical tweak. It wasn't a procedural cleanup. It wasn't a narrow fix to a legal footnote. What happened was a fundamental redistribution of power away from judges toward the executive branch and squarely into a new legal reality that most people still don't realize they're living in. This decision doesn't live in law textbooks. It lives in your daily life. It affects whether a policy you believe violates the Constitution can be stopped immediately, or whether it keeps operating while lawsuits crawl forward for years. It affects whether your rights apply nationwide, or only if you personally have the money, time, and stamina to fight for them in court. And the wildest part, it all happened through something called the shadow docket, where the Supreme Court increasingly makes earth-shaking decisions without full briefing, without oral arguments, and without the kind of public scrutiny that once defined constitutional change. By the end of this, you'll understand why legal experts are calling this one of the most consequential power shifts of the modern era, and why its impact will explode across immigration, healthcare, firearms, voting, business, and civil liberties faster than anyone expected. So let's rewind. Late at night, deep into the early hours, the Supreme Court issued an emergency ruling in Trump versus Casa, Inc. On its surface, the case centered on a controversial executive action tied to birthright citizenship. That alone would normally draw national attention, but the court used this case to do something much bigger, something it had been circling for decades. It ended the era of nationwide injunctions. For years, this obscure legal tool quietly shaped American life. A nationwide injunction allowed a single federal judge, sometimes just one person in one courtroom, to block a federal law or executive action across the entire country, not just for the people who sued, for everyone. One judge, one ruling, 50 states affected. If that sounds like extraordinary power, that's because it was, and whether you loved or hated it depended entirely on whether it protected something you cared about. Over the last 25 years, nationwide injunctions became the emergency brake of American democracy. When a policy looked unconstitutional, judges could freeze it instantly while the courts worked things out. Immigration rules, environmental regulations, healthcare mandates, labor protections, election laws, gun policies, tech regulations, all of it. A judge in California could stop enforcement in Texas. A judge in Texas could derail a policy aimed at New York. Geography didn't matter, speed did. And now that entire system has been dismantled. The Supreme Court ruled that federal judges no longer have the authority to issue universal injunctions that protect people who aren't parties to the lawsuit. Judges can still rule for plaintiffs, but their rulings stop there. If you're not named in the case, you're not protected. That's the pivot. That's the earthquake. According to court data reviewed immediately after the ruling, there are currently 68 active nationwide injunctions affecting federal policy, covering everything from prescription drug access to workplace safety to voting procedures. Under this new framework, many of those rulings are now legally unstable. Over the next 60 to 90 days, lower courts will be forced to revisit them, narrow them, or dissolve them entirely, and the timing could not be more explosive. This lands right as the country barrels toward a high-stakes election season with immigration, healthcare, civil liberties, and voting rules already at boiling point. Every one of those battles just escalated. The majority opinion was written by Justice Amy Coney Barrett, joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their argument is deceptively simple and radically transformative. They say the Judiciary Act of 1789 never authorized judges to protect people who aren't before the court. Judges exist to resolve real disputes between real parties, not to act as nationwide veto machines over Congress or the president. In other words, courts decide cases, not policies. But the real intellectual heavy lifting happens in the concurring opinions, especially Justice Gorsuch's. He reaches deep into early American legal history, back to the founding era and the 1800s, and uncovers a pattern that modern courts largely abandoned. Historically, judges avoided issuing relief that extended beyond the people actually involved in the case. Courts were cautious, restrained, narrow. Nationwide injunctions, Gorsuch argues, are a modern invention, one that exploded only in the late 20th and early 21st centuries. Justice Thomas goes even further. He calls nationwide injunctions a distortion of judicial power that fuels forum shopping, where advocacy groups hunt for sympathetic judges to torpedo policies nationwide. In his view, the practice turned courts into political battlegrounds and undermined democratic accountability. That party, the majority says, is over, but the dissent paints a very different and far darker picture. Led by Justice Sotomayor and joined by Justices Kagan and Jackson, the dissent warns that this ruling hands the executive branch a dangerous advantage. Without nationwide injunctions, unconstitutional policies can remain in effect for years while litigation crawls through the courts. Rights delayed become rights denied. They argue this transforms constitutional protections into luxury goods, available only to those who can afford to sue. If you don't have money, legal access, or organizational backing, your rights might exist only on paper. Justice Jackson doesn't mince words. She calls it a direct threat to the rule of law, warning that it creates pockets of the country where the Constitution becomes optional, enforced only when someone manages to fight back. And that's not theoretical. Within 48 hours of the ruling, the legal system didn't adjust. It panicked. This wasn't the slow procedural response you expect after a major court decision. There were no careful press releases, no orderly timelines. What happened instead looked like an emergency evacuation. Attorneys general from 18 states flooded federal courts with filings that read less like legal briefs and more like distress signals, emergency motions, requests for stays, pleas to preserve injunctions that had been quietly holding the system together for years. Some states moved defensively, trying to freeze the legal landscape before it shifted beneath their feet. Others went on offense immediately, racing to resurrect laws that had been legally dead but never forgotten. Texas didn't hesitate. Within hours, it pushed to reactivate immigration enforcement measures that courts had blocked long ago. Laws that had been shelved weren't being reconsidered. They were being dusted off and rushed back into play as if the ruling had blown open a vault. Florida followed close behind. Emergency motions targeted social media regulations, election oversight rules, and state powers that had previously been constrained by federal courts. The tone was unmistakable. If the restraints were gone, they intended to move fast before anyone could put them back. At the same time, the other side of the map lit up. California and New York launched counteroffensives almost immediately. Their filings weren't just legal arguments. They were attempts to slow a collapse, to preserve nationwide protections, or failing that, to fragment the damage so it wouldn't hit all at once. They weren't trying to win, they were trying to buy time. Behind the scenes, the Department of Justice went into crisis mode. Hundreds of federal lawyers were pulled into emergency strategy meetings. Not one meeting, dozens, spanning immigration, civil rights, environmental regulations, labor law, healthcare, entire areas of federal governance that suddenly looked unstable. Quiet internal memos went out to agencies across the government. The language was careful, but the message was unmistakable. Prepare for dormant laws to snap back into force, not hypothetically, not eventually, possibly within weeks. That kind of internal alert doesn't happen unless something fundamental has shifted. This wasn't about one ruling. It was about the architecture underneath it, because when courts invalidate long-standing legal assumptions, they don't just change outcomes, they change who gets to act first. And in law, speed is power. States understood that immediately. That's why the filings came so fast. Whoever moved first could set facts on the ground before higher courts had time to react. Enforce a law, stop a program, detain people, regulate speech, change election procedures. Once those actions happen, rolling them back becomes exponentially harder. That's why this isn't incremental change. It's a power pivot, and nowhere does that pivot land harder than immigration. For years, immigration policy existed in a strange limbo, aggressively contested, partially enforced, restrained by injunctions that froze certain state actions in place. Those injunctions were pressure valves. They kept the system from exploding while courts argued over authority. Now those valves are failing. States that have wanted unilateral enforcement power suddenly see an opening. They don't need to wait for Congress. They don't need federal coordination. They can act and dare the courts to stop them later. From a legal perspective, this is seismic. Immigration has always been federal terrain. That wasn't just tradition, it was doctrine. Uniformity mattered because immigration enforcement affects foreign policy, commerce, and constitutional rights. But when states begin moving independently, that uniformity fractures. One state enforces aggressively, another resists, a third creates its own standards. The result isn't order, it's patchwork authority, and that's where constitutional crises are born. Inside the DOJ, this is the nightmare scenario. Federal lawyers aren't just defending policies anymore. They're trying to anticipate which laws might suddenly come back to life, which regulations might be enforceable again without warning, which protections might evaporate overnight. And here's the part most people miss. This chaos isn't accidental, it's the signal. When a legal system reacts this violently, it's because everyone involved understands the same thing at the same time. The rules of engagement have changed. Courts aren't just interpreting law anymore. They're redistributing power. States feel it. That's why they're racing. Agencies feel it. That's why they're preparing contingency plans. Advocacy groups feel it. That's why lawsuits are stacking up faster than judges can read them. And ordinary people, they feel it last, but they feel it hardest. Because when dormant laws come back, they don't arrive gently. They arrive fully formed with penalties, enforcement mechanisms, and consequences that were written years ago for a different political moment. The system isn't breaking slowly. It's snapping into a new configuration. What happens next will depend on speed, coordination, and whether higher courts step in before the damage becomes irreversible. But one thing is already clear. This ruling didn't just change the law. It triggered a scramble for control. And the fact that everyone ran at once tells you exactly how much was being held together by legal duct tape. That tape is peeling off now. Right now, there are 19 nationwide injunctions limiting ICE enforcement across the country, 19 legal pressure points holding a single federal system together. Under the new rules, many of those injunctions may not survive in their current form. Instead of shielding everyone, they could collapse inward, shrinking to protect only the named plaintiffs in only the courts that issued them. That sounds technical. It isn't. It's the legal equivalent of pulling out the rebar and hoping the concrete holds, because once those protections fragment, immigration enforcement stops being national in any meaningful sense. It becomes geographic, conditional, arbitrary, two families, same paperwork, same history, same legal posture, completely different outcomes. One zip code gets protection, another gets detention, one court blocks enforcement, another greenlights it. Federal law still exists on paper, but in reality, it splinters into regional versions enforced or ignored based on which judge drew the case. One constitution, 50 enforcement realities, and immigration is just the beginning. The same logic applies to firearms regulations. A rule blocked in one circuit may remain enforceable in another. Crossing a state line could mean crossing a legal threshold you never knew existed. Healthcare access follows the same fault lines. Protections for reproductive care, emergency treatment obligations, insurance coverage standards, all vulnerable to judicial fragmentation. What's legal, reimbursable, or mandatory in one district could be prohibited just miles away. Environmental protections don't escape either. Emissions standards, wetlands enforcement, clean water rules. A nationwide regulation can now be partially alive and partially dead at the same time, depending on where enforcement is attempted. Workplace safety rules face the same fate. OSHA standards that were once uniformly applied could now flicker on and off across jurisdictions, leaving workers protected in one region and exposed in another. Voting rules may be the most volatile of all. Election officials are already sounding alarms, not quietly, not hypothetically, but publicly. Without nationwide injunctions, voting procedures could flip not because a legislature changed the law, but because a court lifted or imposed a rule locally. Early voting windows, mail-in ballot deadlines, voter ID enforcement, ballot curing procedures, all of it subject to judicial geography. Imagine trying to run a national election under those conditions. Different rules activating at different times in different places, sometimes weeks before an election, sometimes days. Confusion isn't just possible, it's inevitable, and confusion is not neutral. It suppresses turnout, it invites litigation, it creates openings for bad faith actors to challenge results after the fact. That's why election administrators fear this moment more than almost any policy shift in recent memory. They don't need chaos to be intentional for it to be dangerous. They just need it to be unpredictable. Now shift to business. This is where the quiet panic starts. Companies that operate across state lines depend on uniform federal rules, banking regulations, healthcare compliance, technology standards, pharmaceutical approvals, environmental reporting, labor classifications. Consistency is the oxygen of interstate commerce. Fragment that consistency, and every national company suddenly becomes a legal risk engine. A compliance framework that works in one circuit may be illegal in another. A reporting standard valid in one district could trigger penalties elsewhere. Corporate counsel are already gaming out scenarios where a single product launch requires multiple regulatory strategies depending on where it's sold or serviced. That's not just inefficient, it's destabilizing. Early estimates already peg the compliance costs of this fragmentation in the tens of billions of dollars annually. And that's conservative. Those numbers don't include litigation risk, delayed rollouts, frozen investments, or the cost of constantly updating policies to track judicial decisions that can change overnight. For regulated industries, this isn't theoretical, it's operational. For small businesses, it's worse. They don't have armies of lawyers. They can't absorb sudden rule changes. A single enforcement action in the wrong jurisdiction could be fatal. And here's the deeper problem. The federal system was never designed to function this way. Nationwide injunctions weren't created to protect plaintiffs out of convenience. They existed because some harms can't be localized. When a federal policy is unlawful, enforcing it against anyone perpetuates the harm against everyone. Remove that mechanism, and courts stop being referees. They become regional power brokers. Judges don't just interpret law anymore. They define reality, locally. The result isn't federalism in the healthy sense. It's legal balkanization, a patchwork nation where rights, obligations, and protections depend less on what the law says and more on where you stand. This is why agencies are scrambling. This is why states are racing to file. This is why businesses are sweating. The system isn't evolving slowly. It's destabilizing quickly. And the most dangerous part is that, for now, everything still looks normal on paper. Statutes remain. Regulations still exist. The Constitution hasn't changed. But enforcement is where power actually lives. And enforcement is fracturing. What replaces a uniform federal order isn't freedom or clarity, it's uncertainty backed by authority, a landscape where outcomes depend on speed, venue, and judicial alignment rather than consistent rules. That's not just a legal shift, it's a structural one. And once a system starts operating that way, putting it back together is far harder than breaking it apart. But there's a deeper pattern here, one that goes beyond this single ruling. The Supreme Court is increasingly governing through the shadow docket. Emergency orders, fast-track decisions, minimal explanation, massive impact. A decade ago, this would have been unthinkable. Now, it's becoming routine. Lower court judges are noticing. Many are hesitating to block even clearly questionable policies, fearing reversal or rebuke. The chilling effect is real. And for civil rights advocates, the implications are severe. Nationwide injunctions were the primary tool for dismantling systemic discrimination. Without them, courts may only protect those brave or wealthy enough to sue. Everyone else waits or loses. This decision didn't just alter legal mechanics. It redefined what protected means in America. If your right to vote, to equal treatment, or to fair process only activates when you can personally afford a lawsuit, then those rights stop being universal. They become conditional. The Supreme Court's 6-3 shadow docket ruling didn't just change how cases are handled, it reshaped the architecture of American justice. Whether you see this as a bold return to constitutional originalism or a dangerous fracture of legal unity depends on where you stand. But one thing is undeniable. The patchwork future is here. Immigration, elections, civil liberties, the economy, all of it will feel the shockwaves for years, and most people still don't realize it happened. So here's the real question, one that will define the road ahead. Did the Supreme Court restore balance by reining in judicial overreach, or did it quietly splinter the foundation of equal protection under the law? Drop your take in the comments, because how you answer that might reveal more about America's future than any court ruling ever could.